I'm Paul Walbeck, Dean of the George Washington University Columbian College of Arts and Sciences. Today I'm talking with Brandon Bartels, a professor of political science at GW and author of the book Curbing the Court: Why the Public Constrains Judicial Independence. Welcome, Dr. Bartels.
Thank you. Pleasure to be here.
The polarization and failure of Congress to legislate has prompted the Supreme Court to become increasingly involved in policymaking. What has led to this point?
Well, I think it's important to underscore the process of how the Supreme Court got to be polarized, which is a symptom of congressional polarization. And if you look at the context of the last 50 years or even more, what you see is a more politicized Supreme Court appointment process with presidents increasingly selecting justices on the basis of ideological congruity and reliability in the long term. The president's partisans want someone on their team to be on the Supreme Court, deciding cases like they would want them to be decided. And that selection method has become more prominent even in the last 20 years or 30 years or so. Just a little bit of historical context. Since President Nixon became president in 1969, Republican presidents had 10 straight appointments from President Nixon until President George H.W. Bush. And from George H.W. Bush onward, there were only 4 Democratic appointments. So Republicans have dominated Supreme Court appointments in the last 50 years. Yet the Supreme Court did not become reliably conservative until arguably 2018, when Brett Kavanaugh was nominated by President Trump to replace the consummate swing justice Anthony Kennedy. And that's what tilted the balance of power on the Supreme Court to a reliably conservative 5-4 majority. So you have a situation where you have a polarized Supreme Court that's been polarized by political elites, by elected officials. And what we saw also in that 2016, 18, 2020 series of cycles is elites sort of overtly politicizing the Supreme Court to their partisan political advantage. So that's sort of the answer. We have congressional polarization. The Supreme Court's polarization has been a slower process, but it's definitely here. And it's here in the conservative direction. Finally, the conservatives, after a 50-year quest to dominate the Supreme Court and to reverse Warren Court era liberal policies, and as well as Roe versus Wade, the pet issue. Yeah, polarization is here to stay, it looks like.
So it sounds like coalition politics is alive and well on the Supreme Court and a really important subject to study. So let's talk some about Roe versus Wade. So does public support for the right to privacy affect challenges that may appear before the Supreme Court on Roe versus Wade?
Yes, I think it does, although I think it's a complicated, a bit of a complicated response. So there's a lot of research, including some research that I've done over the years, that suggests that even though the Supreme Court is not directly accountable to the public, of course, they have lifetime tenure, they, they're not, they very little, they have high degree of judicial independence, long story short. But there are informal constraints that can bear on the justices. The Supreme Court does not have formal enforcement mechanisms, or really any enumerated powers written into the Constitution, which means that they rely on public support to a large extent for their legitimacy. Now, that's a loaded term. I define that term as rightful authority to render rulings for the nation. And it's more of a norm, right? When the Supreme Court rules, what allows it to have its rulings enforced? The other branches have to help enforce them, right? The American people have to comply with them. So there's a web of norms that must be operative for the Supreme Court to have power in the political system. Public support can be a constraint on the justices. If the justices fear public backlash or significant policy disagreement, which is something I study in my research on public opinion, significant disagreement in the public about their rulings, if this ruling is like really politicized in the public, that can be a constraint on the justices, who may then turn back and say, hey, we anticipate public backlash here, we're going to temper our ruling a little bit. Now, coming back to Roe versus Wade, some would argue, well, maybe this will be a constraint on the justices. I think there are at least 5 justices on the court right now who are not crazy about, who are principally opposed to the Roe versus Wade precedent, as well as the follow-up, the more operative precedent, Planned Parenthood versus Casey, which is the 1992 ruling that was jointly written by Kennedy, Souter, and O'Connor. Really O'Connor's baby, if you will, her bread and butter issue. And she really came, and arguably you could say that public opinion was a constraint on that ruling, because what they did, the Planned Parenthood versus Casey said there's a constitutional right to an abortion, but pre-viability, that is the viability, it's all about the viability threshold, the point at which the fetus could survive outside the womb, which is roughly 22, 24 weeks. Pre-viability, there's a constitutional right to an abortion, but O'Connor and colleagues wrote, states can impose reasonable regulations on that right, so long as they don't pose an undue burden on the right to have an abortion. And that case is arguably a great compromise, because it really chipped away at Roe versus Wade quite a bit in terms of the legal standard applied, that the states could make certain types of regulations so long as they didn't ban the practice altogether. And now, of course, we have the Texas law, which is in the news quite a bit. The Texas law outlaws a lot of pre-viability abortions, but it leaves it to citizens to enforce the law. So there's no state action which can trigger a Supreme Court challenge, people are arguing. That's the argument for the upholding the Texas law. Now, what we do know is that this law is clearly in contradiction to both Roe versus Wade and Planned Parenthood versus Casey, which is the more operative precedent, because it places a ban on a whole range of pre-viability abortions. So the Supreme Court, of course, allowed the law to stand. Now, that's very different from then overturning Roe versus Wade. This is one of my pet peeves in the coverage of this case. People are saying, oh, they've killed Roe versus Wade. What they've done is actually more significant, I would argue. What they've done is they've let a law stand that is clearly in violation of one of their key precedents, 2 of their key precedents, Roe versus Wade and Planned Parenthood versus Casey, which are their interpretations of the Constitution as applied to abortion. They're allowing a law to stand that is in violation of the Constitution according to their interpretation.
So when the court's deciding a case, clearly the legal precedents would, like in this area, Roe versus Wade or Planned Parenthood, play a central role in guiding their decision-making, typically. But the role of public views in the area can also have an effect, given their lack of enforcement power or implementation power, as you described it. So how do things like the recent discussion about judicial reform play into this, with discussion of topics like term limits for Supreme Court justices, or instead of a lifetime tenure on the court, they would serve for some period of time? How will that either accentuate or suppress the role of the public in their decision making?
Yeah, so typically efforts to reform the court, or broadly speaking, court curbing proposals, that is, efforts to reduce the court's degree of judicial independence and judicial power in the system, right? Bringing the court a little closer to the public, or one side or the other. Usually those efforts, and we saw this, famously in the FDR court packing episode in 1930s, that these attacks on the court's power and independence can constrain the court. That when the court feels like they're under fire, they back down, right? That's sort of a conventional wisdom, if you will. The discussions of adding seats to the court, of course, President Biden has his commission studying this, and they just released a preliminary report. The issue of adding seats to the courts would be viewed as probably completely politicized and political, because the motivation from the Democrats is to get even with the Republicans for the Republicans not letting President Obama have that seat in 2016, and for their reversal on the position in 2020. So these proposals, on one hand, the chatter, the talk about them, the chatter among elites and the public's very supportive, by the way, of term limits and a mandatory retirement age. But the chatter, so some of that chatter might constrain the justices to a certain extent, and sort of say, okay, we can't push too far on this. Now that could come into play in Roe versus Wade. Would you let that, you can imagine what's going on in the justices' heads. If we let this law stand, what will the public say about us? The key question is, do they care? Do they care? Now, conventional accounts say yes, they do care. The trends suggest that they do know when to back off. When the temperature's too hot, you dial it back a little bit.
So as we were just discussing, the public at times praises the court for decisions or pans the court for its decisions, especially with regard to civil rights and slavery, but in other areas as well. What do you consider to be the best and worst Supreme Court decisions?
So one way to think about the best decisions, especially as law professors have written a lot about in terms of the canon, which the canon of decisions, the best Supreme Court rulings, versus the anti-canon, which law professors refer to as the worst rulings. But certainly among the best rulings that most people will bring up is Brown versus Board of Education, which struck down the separate but equal doctrine and said that the Constitution guarantees equal facilities for the races, right? And this was what drove the integration of the schools and other facilities, arguably drove the passage of the Civil Rights Act, which of course banned discrimination in public accommodations. So Brown versus Board of Education is certainly at the top of the list for most people. Certainly another one at the top of the list would be one of the first rulings that the Supreme Court produced, which was Marbury versus Madison, which many conventional accounts will say that created judicial review, although a lot of law professors say, okay, it didn't necessarily create judicial review. Judicial review was implied by the judicial power clause in the Constitution. Of course, the court's going to have the right to interpret laws against the Constitution and determine their constitutional validity. But it was the first case to strike down a federal law. And so it's very significant for that. And where the Supreme Court really asserted its role hey, we're going to be the arbiters of constitutional meaning here. Now there's debates in the 19th century. Okay, well, President and Congress have a say on constitutional meaning too. So there certainly wasn't a sentiment that the Supreme Court's word would be final on constitutional meaning, but they're going to be a player. So that ruling was certainly important as well for sort of establishing the court's credibility, although it would take longer for the court to establish its credibility because, of course, the next time the Supreme Court struck down a law was Dred Scott, and that in 1857. And that is often viewed as perhaps the worst ruling of all time, saying that slaves at the time could never be citizens of the United States, and basically keep leading to the Civil War, long story short. That ruling would, of course, be overturned by the Civil War amendments, which banned slavery, gave former slaves citizenship in their states and the federal government and the nation, and gave former slaves the right to vote.
So you've mentioned Marbury versus Madison, and it's important to note that the judiciary is a really important part of of our democratic governance system. So how can we ensure that the courts retain that independence and integrity?
Yeah, so this is an important question, not only in the United States, but increasingly around the world, where judicial independence and judicial power comes under attack by authoritarian leaders who want to get their policies through, and if the courts are in the way, they're going to trample over them, right, one way or the other, via court curbing, removing justices, changing tenure. I also think it's important in the United States context to note that not everyone wants complete judicial independence. There's this spectrum of independence and accountability that's the cornerstone of democracy, right? That the people have a say in dialing back policy, right? If policymakers are generating policies that are too extreme, the public has a right to throw them out at the next election. That's an accountability mechanism. That's at the cornerstone of democracy. Now, we give justices on the Supreme Court lifetime tenure and a modicum of judicial independence. But it's important to know that not everyone really loves judicial independence. There's almost sort of a sweet spot where you want the justices to have enough independence to be neutral arbiters. When you get a challenge about health care policy or abortion or affirmative action or religious freedom, not only the litigants directly involved in the case, but the public needs to know that this court is going to be a neutral arbiter of the dispute that's in front of it. And that dispute in front of it's going to have wider implications for the whole country, right? That's a basic sort of norm of procedural fairness. Again, we expect the Supreme Court to be a neutral arbiter of disputes like over elections, for instance, which increasingly could come into play. And of course, the Supreme Court in 2020, in that 6-3 majority ruling, dismissed a Republican challenge that even a lot of conservatives said, okay, this is a real stretch. Texas can't sue 4 other states that Trump lost and say these states can't be counted, they can't be certified, or they can't be counted in the Electoral College. And the Supreme Court dismissed that out of hand unanimously. Again, thinking about there's this calibration between independence and accountability. You want an independent court that can decide these cases neutrally. How to get that? Elites have to respect the court's authority. Then you get to that other question, though, of what if the Supreme Court now how do you judge this? What if the Supreme Court objectively violates the rule of law? What do you do then? Maybe those court curbing proposals or dialing back judicial independence might be justified. Then you're in a different kind of game that can be tenuous for rule of law maintenance and also democratic norms.
Well, thank you, Dr. Bartels, for sharing your expertise with us on this important topic. Your insights are so valuable in moving us forward in these challenging times.
Thank you. Pleasure to be here.